there's this attitude that we have in our country that suffering makes you stronger. So it's okay to put through the mill because you will emerge hardened and ready for the big bad world. Personally, I'm not a believer in this philosophy. Hard work, yes. Personal sacrifice, yes. But ultimately, it has to feel worthwhile and enjoyable while you're doing it. Because not of some reward that will ultimately come your way, but then right then and then. So don't simply be the version that someone else expect from you. Learn to exercise your own judgment after considering your personality, your likes and dislikes, your temperament, and your potential. Because it's not about conformity, it's about individuality, and we should never succumb. Hi everyone, you're watching the Virtual Amicus and I'm LODHA. And I'm pleased to inform that only within 10 months time, we could record as many as 99 episodes plus 2 special sessions. It would not have been possible without the support that I received from all the members, all the speakers who were kind enough to give their consent and be a part of this wonderful initiative. Now, today we are just one short of our maiden century and we are recording our 100th episode. And for the first time on the Virtual Amicus, we have a virtual seniors roundtable and featuring a galaxy of stars from the legal fraternity. It's difficult to get hold of them on a working day and to get as many as 7-8 leading and stalwarts from our fraternity. It's not easy. And the topic for today's discussion would be what not to argue in a court of law, because all this while we've only been taught what to argue, what are the tips that we've learned from the seniors, but what not to argue is something really very important. So joining us today on the Virtual Amicus, as I said, Galaxy is a battery of senior advocates. And we are joined by Mr. PALLAV SHISHODIA, Learned Senior Advocate, Supreme Court of India, Mr. RAJDEEPAK sir, Senior Advocate, Rajasthan High Court and Additional Solicitor General of Rajasthan High Court, Mr. RAJENDRA NARAIN MATHUR sir, Senior Advocate, Rajasthan High Court and former Additional Advocate General for the State of Rajasthan, Mr. SUDHIR GUPTA, Senior Advocate, Rajasthan High Court, Mr. VIRENDRA LODHA, Senior Advocate, Rajasthan High Court, Mr. MANOJ BHANDARI, Senior Advocate, Rajasthan High Court, and Mr. SINGH, HORA Advocate and Managing Partner, SS HORA and Associates. Now, there was a bereavement in the family of Shri Anil Mehta sir, a Senior Advocate and Additional Advocate General, so he could not join us. We will definitely miss his presence and we hope to see him in any of our episodes future. So we were informed that Mr. Rastogi has a meeting lined up. So sir, the floor is all set. Over to you. If you could unmute yourself.
Am I audible?
Perfectly audible, sir.
Some disturbance in your system because voice is breaking. Anyway.
Is it? Yes, please.
Yeah. So first of all, good morning. It is a matter of great pleasure for me that Jai Lodha, lawyer, I can say, I have seen him growing, son of our friend Virenji. Even when he has started he talked to me. He might be, and it was a standing invitation from his side. But I missed it. But today I got this opportunity. I am really thankful, Jay, to you for giving this opportunity to me. And normally the topic I come to, because time is only 5-7 minutes. The topic is what not to argue. Jay, when I heard about it, really, it was really a difficult thing to say something about what not to argue. We know what to argue. We know it. But what not to argue, really, it is a very difficult thing. And you have raised this issue, very good issue. And all the speakers, they are very eminent speakers. Eloquence is there. And we will be benefited. Of course, I will be missing. First of all, what not to argue in the court. I put it in a different manner. I say what to argue in the court. If that is argued, the rest is not to be argued. To be very simple, precise. I'll elaborate. So what is to be argued? Everybody knows. And what is the point which is not to be argued? Everybody knows. But one should also know what not to be argued. And that is having its own importance. Now I come straight away to the point that normally what we do is that we cite a law or we cite a case which is favorable to us. There are two exigencies. One, we are ignorant at times it has happened with me. I very candidly, I accept that I was not knowing there is some other law which is happened with me. This is one aspect. And there may be a situation that where one knows that there is another point which has already been decided against you. But still, at times, not all, some of our fraternity brothers, sisters, some, not all, which I have observed at least during last 38 years, that at times they prefer to argue what is in their favor, ignoring what is not in their favor. So my personal approach is that even you argue what is in your favor, but at the same to the court saying that, sir, this is the law which is in my favor, but this is the law which is against me. But the lawyer should have that courage, that quality, that acumen to distinguish that what is against his client is not properly decided for so many laws, and difference is required, difference of opinion. So this is the right approach, and everybody will agree because everybody is a respected counsel. So with the thing which I could perceive that at times it happens, so we should ignore. Now, another point, directly because the time is short, I am just coming to the points, main points which I have perceived. That the point which is not raised, sometimes so many issues, they are never raised in the petition. And they are also being argued. And there is a limitation that the point which is not properly raised or pleaded should not be argued. Unless it goes to some legal question, certainly that can be raised, or it goes to the very root of the case. I mean, the total jurisdiction. So certainly one can raise it's an established law, nothing new about it. But at times what I have felt that those points, they are being argued before the court, which are not in the petition, not pleaded, and argued for hours together. And certainly we cannot interrupt, and we should not interrupt. So, but the precious time of the Honorable Court is taken away. Suppose Mr. A is arguing a point which is not pleaded, and I just start my arguments. I'll say, sir, this is not pleaded. So after having argued for 1 or 2 hours, again we come to square zero. Sir, this point was not pleaded. So, I mean, this thing, particularly to the young lawyers, we all know it, we are very senior, we follow it. Particularly the young lawyers who are just emerging, they should follow this thing. So it will save the precious time of the Honorable Court. Third thing, which sometime it happens in the court, that no personal allegations. It should not be. Sometimes we see some personal allegations, some stigma, something. So not even the brother lawyer, but even against the client, other client, because client, he is representing his client, I am representing my client. So there is no point in leveling allegations and all that. It should not be argued. Then repetitive arguments. The repetitive arguments, normally they waste the precious time of the Honorable Court. It happens. We see in the court. Sometimes we also indulge. I am also one of them. I am also, I cannot say that I am different. I am also one of them. It should be avoided. Repetitive arguments, they take much time and no result is there. Every time then if some, am I audible?
Perfectly audible, sir.
Because, yeah, now you're visible. So, and sometime the validity question comes, which I have seen, validity of any act, rule, regulation, circular, whatever OMs, that is under challenge. And that is already decided. That of High Court. So certainly one can differ. I'm not saying one can differ. So, but the point should be thrown why this earlier judgment is per incurium. That point is left. And we argue again that same point. What is the point in arguing? Unless you can show to the court that the point which was earlier decided, it did not consider the earlier Supreme Court judgment or High Court judgment. It was in ignorance of the earlier judgment. Say it was a per incurium. Nothing is argued. But every time it is raised, number of times we see, again steals rather the precious time of the Honorable Court. Why to raise such issues which are already decided? And some cases are already decided even at the level of Supreme Court. Finally decided. The matter is not res integra. Again, the same point is being raised, which we have seen. So these things should be avoided. And if we do it, certainly we talk about the pendency. Because yesterday I was in a webinar in MIT University. Again, the Vice Chancellor was saying that he filed a case, civil case his grandfather filed and decided when not mature. Pendency, we talk about the pendency. We talk about the flood of litigation. This is all because, and to some extent, with due respect, I am also one of them, we are responsible. So we should avoid. Such points should not be argued because time is too short, matter is so lengthy, and all other speakers, they are much more wise than me. They will throw light, and I'll try to join for some time, but I'll quit in between. I am handing over to you back, Jay. Thank you.
Thank you so much there for the erudite, for your valuable insights. And now the next speaker is Mr. PALLAV Shishodia, sir. He's a senior advocate at the Supreme Court of India. And just to give you all a brief introduction about our speaker, Mr. Shishodia is presently a busy practitioner as a senior counsel in civil, commercial, criminal competition, and other regulatory laws. He's briefed regularly on behalf of central and state governments, CBI banks, Exim Bank, public institutions like Competition Commission of India, Statutory Corporation, and various corporate houses before the Honorable Supreme Court, Honorable Delhi High Court, NCLAT, CCI, tribunals, etc. He was designated as senior advocate by Honorable Supreme Court of India and practices all branches of law on 17th of October 2008, and he's been practicing in Delhi since 2000 and joined the chambers of Shri Ashok H. Desai, former Attorney General for India, and appeared in several cases, including a special counsel for CBI in fodder scam in central government to defend the Sardar Sarovar project. And he's practiced also back in the late 80s in Rajasthan High Court at Jodhpur with Father late Shri D.S. Shishodia, veteran leading senior advocate of Rajasthan with large practice in all the subjects. And he's also been a junior counsel. This was back in the mid 80s on the original side of Bombay High Court in the chambers of Shri G.E. Vahanvati, former Attorney General of India, after enrollment as an advocate and upon his graduation with LLB from Government Law College, Mumbai. So thank you so much, sir, for taking out time. The floor is all yours. Over to you, Shishodia, sir.
Thanks, Jay, for introduction. And I really feel privileged that I'm to young friends through the forum of virtual amicus, because the last I heard of virtual amicus was invitation to my son Manan to speak on insolvency law. And I almost got a feeling that we are now old and outdated. There are the young people don't want to listen to us. But today I really feel privileged that you consider it worthwhile to pick on little bit on the wisdom and the experience we think we have gathered over the years. Now, what not to argue has more to do with wisdom, and don't take it, or let me put this disclaimer that whatever I say, don't take it as a do's or don'ts, because all these tips or the principles need application in the given case. So if whatever I say, don't take it as a absolute do or don't, and you discard them, but sometimes you would be discarding them at your peril. So now most of the young people have a very common mistake, which at least I made so many times as a young counsel, that is of going to court with a very predetermined line of argument. Now, you get very passionate about the case you get because as a junior, you get cases once in a while. Then when you talk to client, you really feel his pain, his sense of justice, and you want to convey to court. Then you do research, then you study law. And I always say that when you know limited things, you are more certain about the things. And when you know more, you become more and more uncertain. So in your junior, about one position of law which you research. So with this deadly combination of uh, translating your client's pain with your research, you go very determined line of argument. You go to court that come what may, you have to put across this point of view. Now, this becomes a folly because sometimes you have a judge who is, because he has read the papers or he somehow is familiar with the matter, or by asking some questions, he is able to make a point in your favor, or he is favorably inclined to you. But you persist to argue because you are full of your argument. And there, sometimes you give up some points by which the judge feels all of a sudden that what he is thinking is not correct. There are other things, and you come out with a order. So it becomes a case of over argument sometimes because you are so determined to argue. It also happens, it's also very bad when in favor of you on the point you think he should be with you, because it is a fair possibility that he may be inclined towards you on some other point in the matter. So, sometimes we argue on merit, sometimes we argue on limitation, sometimes we argue on procedural law. And it depends. Ultimately, your job is to persuade a judge or a bench. And in that persuasion, sometimes this whole idea of with the point you think he should be persuaded, you lose the flexibility or the objectivity of persuading on the other point. And they always say that the judge's point is the best point. So your perception that you are good on one point and you want to go and keep on persisting on arguing on that point, annoy the judge, who may be with you on some other point, may get so annoyed that your good point also goes, and the good point he thinks in your favor may also go. So the pitfall going with a determined line of argument and with a determination that come what may, I have to make the court hear me, whatever be. So that is something which should be avoided. As a point, I would like to share as a point what not to argue. Now, there is a pitfall in this suggestion because or for any lawyer, it becomes very difficult to go to court without a broad theme of the submissions. Now, this is the other side of it, that one is that you don't be very sure or be very persistent on one point you want to argue, but at the same time, you have to have certain theme in your mind. And therefore, it becomes a challenge to how do you tackle with the distractions which come from court, or with the questions which come from court which distract you from your line of argument. So you go with a broad theme, but at the same time, you must go with the intellectual flexibility and openness, and also a notion that there may be other way of looking at you in your favor, or there may be a way to persuade the bench with your line of argument after taking care of the questions and the sensibilities of the bench, which may not have anything to do with your line of argument. So this kind of flexibility is something which we miss, and this is what we must avoid. Sometimes, even as seasoned advocates, we tend to make this mistake, and we should avoid this. Now, the other thing is, Mr. Rastogi has also already said that we should never be personal to the opponent or to the opponent, either the counsel or the client, because there are situations when you have best of the case and your opponent has worst of the case. But that should not become a cause of any kind of a personal incrimination, or because after all said and done, we are only propounding the cause of a client, and there's nothing personal about it. It may be good, it may be bad, it may be indifferent, but we all have our duty to propound that point of view with certain dispassionate and impersonal approach to it. The another tip I would like to share is that never crack a joke at the cost of judge, because this is the worst thing you can do. Mr. Mradul, the old grand old man in Jodhpur, always used to tell us that the judges, the biggest thing they have is the ego. Ego, because they are in position of power to decide or take a view for or against you. And it is always advisable that you treat the man of power with certain dignity and respect, and never crack a joke at your cost, at the cost of judge. You must always crack a joke, or to lighten the atmosphere by cracking a joke, always at your own cost. And now these are this is one of the tips, and a lot of things we can talk and discuss whenever we meet personally or in the question answer session. So I'll conclude with this this thought for all of you to, for all the young friends to keep in mind and apply it selectively and with wisdom, a rigid manner. Thanks a lot, Jay.
Thank you so much, sir, for your valuable inputs, for your valuable insights. And now we are joined by Mr. NARAIN MATHUR. Sir, he's a senior advocate by profession. And just to give you all a brief introduction about our amicus, he specializes in the fields of practice, constitutional issues, arbitration, land acquisition, service matters, election laws, miscellaneous issues, social interest litigation. He's been practicing since 1982. He's represented Indian Railways, Jaipur Development Authority, Rajasthan Financial Corporation, various universities, and he's also served as additional Advocate General. He's the former Additional Advocate General for the state of Rajasthan. Now I request Mathur sir to please unmute himself. The floor is all yours. Over to you, sir.
Thank you, Jay. It's a pleasure to be in your company, and we are very happy that you are doing a constructive work. Before I proceed, I am to argue. And the issues which I would like to formulate are, and that every member of the bar is a trustee, honor and prestige of the profession. When we argue the case, we are trustee of the honor of the entire profession. Keeping this in mind, we must advance. The first thing which is to be kept in mind is frame the issues which are to be argued by you. After the framing of the issues, inform to the court that these are the issues on which I propose to argue. Thereafter, be specific, avoid anything which is irrelevant. So first thing which I am suggesting is, keeping in mind that you are a trustee, make your submissions, avoid anything which is irrelevant. Second, do not jump to the law. Every law is to be first applied in the facts of the case. Normally what is seen is that this case is covered by that judgment or another judgment. My suggestion is do not jump to the law. First, explain the facts to the court, then apply the law in it. Third, do not sacrifice the fellowship is one of the important things which must be kept in mind. Fellowship towards your opponent, fellowship towards the bench also. And how this can be done? This can be done only when you are not identifying yourself with the case. Never identify with your case. Now, the moment you frame your issues, you will come to know that these are the issues which can be argued, which cannot be argued. And the moment the things become clear to you, then avoid anything which is irrelevant and do not identify yourself with the case. Friends, law is a science which affects the entire society. Therefore, I would suggest that you owe a duty towards the society, not towards a particular case. Avoid any argument which can lead to a wrong judgment. Judgments are ultimately given on the basis of the arguments which you are advancing. And if you are arguing a point which can be subsequently termed as a bad law, even at the appellate stage, then you are not serving the society. So try to be society oriented. That your duty is not to assist the court in laying down a wrong law. Third, please do not sacrifice the courage. A lawyer must necessarily have the courage to speak and should have courage to speak the truth. Therefore, see what Gandhiji said. Gandhiji said, wrong means can never take you to right end. Gandhiji also said that the means and ends are inseparable. Please keep this basic principle in the mind. You can win a particular case, but wrong means will ultimately not lead to success. And for the ultimate success, personal success, success of the profession, you must know that what are the means which I am adopting. The moment this fact is clear to you, you will state only the correct law and correct facts. I would further say, do not be vague. Normally what happened, instead of being specific, the arguments are advanced which are vague. So my suggestion is, please do not be vague, be specific. Be specific to the law. Read specific and read specific facts. This leads to another thing. When you are reading a statement, when you are reading an evidence, please read the entire evidence, not in the piecemeal, which is favorable to you, avoiding the thing which is not favorable to you. So give complete and all facts. Last but not least, do not forget the courtesy towards the lawyer opposing you and towards the court. But this does not mean that towards the court you become so humble that you completely forget and avoid speaking the truth. Always have courage to speak the truth while maintaining the courtesy. Do not argue any bad issue. Lawyers also cross-examine. In the trial court, cross-examination is there. My further suggestion would be, when you are in a trial site, do not add so many witnesses. Because when you are cross-examining a witness, each time you are putting your finger in the hole of a snake. Try to select your witnesses. Ask specific questions. and confine yourself to the specific answers. Also, do not tutor your client to give a specific answer, because if you tutor, then ultimately he will not speak the truth. Friends, these are a few suggestions to me. On top of it is, as I said, you are trustee of the profession. When you keep this thing in your mind, probably you will not argue anything which is irrelevant. Thank you, Jay. Thanks a lot.
Thank you, sir, for your valuable insights. Now we are joined by Mr. Sudhir Gupta, sir. He's a senior advocate. And just to give you all a brief introduction about our next speaker, he's a front-ranking lawyer, highly appreciated in constitutional as well as corporate litigation. He enrolled back in 1985 when he was appointed as standing counsel for the Government of India from 91 to 94, practices mainly in Rajasthan High Court, and has vast experience of successfully arguing a large number of matters pertaining to constitutional land acquisition, taxation, intellectual property law, corporate laws, and issues such as environment, society, protection of rights of individuals. He's also a well-known, recognized person in the field of mediation and has been instrumental in mediation and resolving a large number of contentious disputes involving complex legal issues by way of out-of-court settlements. And he's also been actively associated with international organizations such as the UIA, SARC Law, Indo-American Chamber of Commerce, to name a few, and also participated in several international conferences in India, abroad as a speaker and otherwise, and organized many national and international conferences and seminars. So, sir, the floor is all yours. I request you to unmute yourself. Over to you, sir.
Yeah. Let me compliment you and congratulate you. Team of virtual amicus, which basically you are the face. Reaching milestone, which is the 100th session today, after having done 99. Difficult COVID, keeping is a only which Jay LODHA could have done. So hats off to you, Jay. It's a great job. And thank you so much for getting me together with all the respected seniors who are on a topic which, as RAJDEEPAK said, dear to all of us, very important to all of us, and time very difficult. The moment, this post by you to me, chat with the associates, with the interns, and I said, look, very interesting. Everybody said, oh, now they got things what to argue. This is something which is brought before us to argue. Experience this in the now everybody said, sir, we'll just look up the Google. I said, please do. Okay, and I'm telling you, I was so happy. They looked up the Google, they came with an answer that there was nothing on Google in respect of what not to argue. So I said, this assumes importance. Why Jay has picked up this topic? Because it is not there that me or any of my colleagues, they pick up and while we are all this, and then we quickly make a note of it and we give it to this. I think that became a difficult task and that made me thinking. Yeah. So I think, picking up this topic was a wonderful thing. Able to contribute in some manner. And I not only contribute, I also thought, let's see what my friends have to say. Because I feel as a trustee, RN says as a trustee, I do agree with them very hugely, immensely. And I would always say that we are all lawyers and we should always be very open-minded. As PALLAV says, predetermination, yes, exactly, in all walks of life. And then I would also not want, having got an opportunity after my learned friends, it is that one is, I would start off, is a very important point is, RN has said, PALLAV has said, even I think deeply touched, but not to be repetitive. So I would not be doing, first is not to be repetitive, and I would also follow for this session, not to repeat what has been stated by any of my friends. Now, I think before I say what not to argue, I have to bring to you, I think, what we learn is what we see in the court. There in the court, all of us now, we are also physical. there was a matter which was regarding a tax matter being argued by a counsel, very able counsel, learned, quite senior at the bar. The issue was he was assailing a demand of tax and he had come against a show cause notice where a pre-deposit was required to be made. It was a contested matter. The other lawyer was there. The court was all with him on the issue of jurisdiction and was with him on the point of even pre-deposit, which had been insisted upon by the adjudicating authorities. Now they started off and he was very well prepared, but he was very keen to take the court even on the merits of the case. At the initial stage, the court observed that, listen, we are with you on this. Please, this is not the issue. We would like to grant you an interim protection, relegate you to the adjudicating authority, but don't bring up anything regarding merits of the case. But as you know, it's a mistake which is committed. When the court is with you, you feel, I've already got this, let me get something more. He started he said, there is nothing on the merit. And can you believe it? The order which ultimately came was against him. He didn't get any relief. And the court said, keep it in mind, I'm just quoting. When you come to the court in extraordinary jurisdiction, it is kind of a double-edged sword. Okay. And then when he came out, he said, I think I overstepped my limit outside the court, because it is something, that was a point I thought about it. I said, Jay was so right in bringing up this topic, what not to argue. This brings in that we should know what to give to the court straight away. Never give to the court which the court is not wanting. Never argue something which the court is not wanting you to argue. Stop at that, and that is the thing which comes up. We would be knowing a lot many things because we are, let's say as a counsel, the client is there, we on it about the case. Could be, so we have the facts, we have the statute, we have the case laws. Now it is for you as a lawyer to see what exactly is to be given, which would give the point that don't give and don't argue everything before the court. You should see what is your star point. Many a time there is a tendency that you give many points and then the main star point gets lost out. And that is the time it becomes very difficult because one has to see the court is there. It is a very, time span is very short. It's not only your case. They have a large number of other matters which are of all kinds of matters are there. You have to see that when the judge is there, you have to engage the judge in a manner that he listens to your point before he drifts away. So never argue, never give to the court something which is not really required, which is frivolous, which is not your star point. That is important. Then another thing is there. I would say what not to argue is to be seen in the context of three primary factors. One is your client, you have a duty to the client. But as has already been said, never identify, never take up his prejudices or opinions to the court. Don't argue what exactly he's wanting. You have a conscience. We are trustees, as RN says. We are, if not the direct conscience keepers, we are contributing to it as even assisting the court also. So we should be careful in what we give the best. We are holding a brief to get the maximum relief for a person, but not at the cost of conscience. As has already been said, we have a duty towards the society. Never get a wrong order has already been said, my friends. So one is your clients are there. So don't argue exactly what he's wanting. You have to see that to the extent of getting him a relief, what are the points you should be and what is something you should not be giving to the court. Then another thing is very important, never argue in a manner. I would say, never argue with a judge. A judge is always right. When you are before him, you should also see that we have a job as a lawyer to put up the case in the best possible manner, to the best of our ability, but only to persuade the judge and never to annoy the judge. Never argue anything which would annoy the judge, because there is no way of your getting an order from a judge if you have upset him. And I'll tell you, there's something which I learned when I started in 1985, as you just mentioned. One judge, I got an opportunity which also taught me what not to argue was Justice Mahendra Sharma. All of us, he was supposed to be, everybody said, very difficult judge. But I'm telling you one thing, I learned a lot by what not to argue and how to exactly argue. He never wanted that you should make any, one is, don't argue which is frivolous. Don't argue in a manner as to mislead the court. Don't give anything which the court is not wanting. And he was the best judge. I think that is what we have to stick to in most of our cases, that we never, nothing should be done. It may be in a position to get a relief to the client, then I think we are doing a disservice to the entire profession when we are trying to obtain an order by placing or putting across something which we do not believe in, which is not the correct law, which is not the correct position of factual aspects, or which the judge does not believe. I think that's a very important. And then again, what happens is, when you know what you should not be arguing, and then you are on the right side, there is always, the judge forms an opinion about it. And that sets your credibility. I've come across many of the judges and many of the lawyers. The lawyers don't even open a file, and the judge takes him at the face value, and they pass an order on the basis of what has been submitted to the court. So very important is, don't give frivolous, don't give any misleading statement. Try to be with the judge to the extent possible of getting a relief, because what is important is, it is going to set in line your credibility, your goodwill, your image before the court. Another thing which comes up is our duty to, again, I've also spoken about it. We should not argue. I think very important is, many a times we have seen that we indulge in arguments lawyer to lawyer. I think because lawyer will never agree on the opposite side. Why would he agree to any of this? And that leaves even a bad taste outside the court. So one is, you should never argue with him across. Then second is very important, all of us have to learn, and it is very, I find is meant, the Supreme Court, PALLAV is defined always, Bombay High Court, many other courts, never argue on submission when the other. Jodhpur is also, I think I would say, all the youngsters, when the other counsel point, because what happens, and many a time, let's say I'm making my submissions and Manoj is also making his submission. Now I find the judge in favor of Manoj at that point in time, because suddenly I rise and I try to counter point in time. I think that is not a good or a healthy practice. We turn, and I think which goes a long way in the profession. Brotherhood is made before the court. So these are the points which I would want that maybe should be kept in mind, but it's a learning process for me too, because I'm learning on a day-to-day basis. Okay, and one more thing I would like to say, one last thing. I started off before Justice, I had the fortune to appear before Justice, J.S. Verma, who went on to become the Chief Justice of India. And I was appearing on KVIT. The judge, in fact, before he started off, I just rose and I said, I've entered KVIT on behalf of so-and-so. He said, immediately issue notice. Okay, and even granted interim orders also. So I said, Your Lordship. He said, I think you are very keen to argue. Okay, we'll hear you at length. Okay, so that was a learning what not to argue. From that day till now, when we appear on KVIT in many of the cases, I just wait for an opportunity and the judge to ask me. So we should argue or rise to argue only when we are called upon. That's about it. So I would, Jay, thank you so much, and to all my learned friends.
Fantastic. So that was indeed a learning session for all of us. Now, next we are joined by Mr. Virendra Lodha, senior advocate. And just to give you all a brief background about our next speaker, Mr. Lodha was designated as a senior advocate in 2011. He specializes in taxation matters, service matters, labor, civil, constitutional, and sexual excise. And he's also been a senior standing counsel for CBSE, which is the Central Board of Secondary Education, Jaipur Vidyut Vitran Nigam Limited, Ajmer Vidyut Vitran Nigam Limited, Jodhpur, Rajasthan Rajya Vidyut Prasaran Nigam, Rajasthan Rajya Vidyut Utpadan Nigam, RICO, Rajasthan Financial Corporation, Delhi Public School, Rajasthan State Ganganagar Sugar Mills, RSRTC, which is Roadways Corporation, Jaipur Nagaur Anchalik Bank, Ajmer Central Cooperative Bank, and the list goes on and on. He's also been early senior standing counsel for the Union of India Railways, State of Rajasthan Home and Police Department, State Insurance and PF Department. So thank you so much, sir, for taking out time. The floor is all yours. Over to you. Now I request you to unmute yourself.
Thank you for inviting me along with Shri R.D. Rastogi Sahab, R.N. Mathur Sahab, PALLAV, SHISHODIA, GUPTA, along with my younger brothers, SWADEEP, HORA and MANOJ Bhandari. Well, the subject as chosen by you, quite difficult, be that as it may, to hear all my elder brothers, including Shri R.N. Mathur Sahab, SUDHIR GUPTA Sahab, PALLAV ji, as well as R.D. Rastogi Sahab, and it has made my task more easy. Before starting, I will just reiterate what Shri R.N. Mathur Sahab has said, that since every lawyer is a institution in itself for the purpose of preparing and framing the issue and to lay down what has been stated by my previous senior advocates and elder brothers, I will propound the same in following manner. Every problem has a central theme, and all its activities and occurrences within the problem happen in and around this theme, and the problem is to be read in conjunction to this theme. Meaning thereby, once you have understood the theme, all your ideas and arguments should be formed, keeping in mind the same, circling around the same. Meaning thereby that, first of all, there should be never repetition of our arguments. That is, at a fundamental level, every advocate is supposed to make submissions strictly within the consonants and parameters of the averments made as well as the law in question. The assertion is something I personally keep in mind when trying to convince a judge. The judge may be making the most outrageous assertion, but yet they cannot be wrong, in the sense that in case one should be bold enough to point out what is incorrect either on law or on facts if a lawyer is thoroughly prepared, but in no way to curb the irreparable damage while doing so to your client or the institution at large. Remember, a judge, even in real life circumstances, can be proven wrong or overruled, but only at a later stage. They cannot be wrong at a particular moment. However, by the time they are proven wrong, your client has lost something very essential, which is his or her valuable time, and you have lost something more essential, your round. So it is always in the interest to make the judge align with his or her views with you and never to go into face off. Then how to disagree while agreeing? This is a very important subject, in the sense that advocate cannot say outrightly that he disagrees with the court. Advocate agrees most respectfully when he says, agreed, your sir. However, the counsel would like to point out that and state the solution that you find to be more preferable. Remember, it is not your job to annihilate the opposition, It is your job to get your client whatever for which he has come for, but in a legal perspective manner. Then in the end, I would just sum up what is the towards the court. Always respect a judge. Never state the wrong law knowingly. Never hide from the court any substantive law regarding a particular point in dispute. Always formats which Sri RN Mathur Sahab has also stated, keeping in mind the law in its entirety. Just because a certain law does not mean it is non-existent or the court would be unaware about it. Never mislead the court from the wrong facts, because at a particular given point of time, if you mislead the court, ultimately when the court comes to this conclusion that you have misled the court, then it, for all times to come, it will be not only laying down a bad law, but your image shall also be shaken. Being calm and composed, which Sri SUDHIR GUPTA and Sri PALLAV SHISHODIA, out of certain things which are not advisable to be done in a court, one is to directly attack either the court or your opposition. Sri SUDHIR GUPTA ji rightly said that we have to be patient when the opposite counsel is making submissions, never to interrupt. And lastly, I would say that whatever bit I have learned, I had an occasion to appear before Honorable Justice S.C. Agarwal, as his lordship was, while he was sitting in service writs bench, and I was an associate and a junior to Honorable Justice G.S. Singhvi Sahab, and service writs Sosa was, as and when we were making submission, Honorable Justice S.C. was not always encourage us and say that, all right, you, Mr. Consul, you come prepared on this point, and he used to accommodate us. Thereafter, we used to research on that point, and ultimately we used to make submissions in the next date. So whatever I have learned shortly, I have learned a lot of, not only from my Guru, Honorable Justice G.S. Singhvi Sahab, but also from Honorable Justice S.C. Agarwal Sahab, as his lordship was. To sum up, I would say that whatever has been said by Sri RN Mathur Sahab, Sri RAJDEEPAK RASTOGI ji, PALLAV SHISHODIA ji, and SUDHIR GUPTA Sahab is that never be personal or identify with your client. You are there to make your submissions. It is ultimate for the court to decide and come to a logical conclusion based on the facts and the law prevent there. Thank you, Jay, so much for making a part of this 100th episode. Thank you.
Thank you so much, sir, for your valuable insights. Now we are joined by Sri Manoj Bhandari, sir. He's a senior advocate and he's been practicing before the Honorable Rajasthan High Court, principal seat since 1992. Majorly deals in civil disputes, writs, and public interest litigation. Has experience in matters related to excise, customs, and also with respect to matters related to service jurisprudence. He's dealt with wide ranging of family disputes, mediation proceedings, and also handled briefs pertaining to white collar crimes, especially under Prevention of Corruption Act, specializes in dealing with matters related to land revenue, land disputes, and has experiences representing both in High Court, various tribunals, and also performs administrative management functions related to practice of law. And he's remained a panel law for the Commercial Tax Department from the year 1999 to 2003, also of Indian Railways in Rajasthan High Court and Central Administrative Tribunal back in 1997 to 2018. And has also represented Honorable Rajasthan High Court, Jodhpur Vidyut, Ajmer Vidyut Vitran Nigam Limited, and the list goes on and on. So thank you so much, sir, for taking out time, on Saturday, and the floor is all yours. I request you to unmute yourself. Over to you. So we can't hear you. No, sir, we can't hear you. Over to you, sir.
Yeah. Thank you, Jess. Interruptions. So it's really my pleasure that I'm here, a part of this August gathering today, which is, and I must congratulate you, Jay, for this 100th episode of this virtual. I think it's very helpful for the young lawyers. And before you in such a topic for which everybody has spoken, but I would just begin with that what not to argue before the court. In my 30 years of experience, I've seen that you have to be very specific. You have to be master of your facts. What happens is the judges come in the court while reading the files. There are a number of matters listed in admission. So a lawyer has to be very specific, master of his facts when he's arguing for admission. Differently, you have to be very patient with the judge. Never speak over the judge. You know, many a times it happens is that in a curiosity to give your all the facts, you start speaking without even waiting for the judge to respond. So I have noted on a number of occasions that on account of this, you irritate the judge. You know, many a times it happens is that in the yeah. So I just wanted to convey that you have to be very specific. Your facts should be clear. Don't irritate the judge. Be patient with the judge. Don't, wait for your turn to speak, and put your points in such a manner. Don't avoid the query of the court. You know, take the judge where you want him to go. But if there is a query from the court, you should specifically answer that immediately. So in my humble submission, which you make, you know, that you have to be very, say that sometimes you have to be persuasive also. There might be, although you should not be repetitive, you should not become angry, you should be careful with your colleague, the opposite counsel. But at times, I have noted in my heydays that when you are a younger, you are with the senior, the judge generally don't care about the juniors. You know, the senior, whatever you speak, you know, it's very practical. I'm talking about very practical things. The point which you are making may not be acceptable to a judge, but sometimes when the same point is put forth by the senior, that is acceptable. So you feel that, you know, you said the same thing, but when your senior came and said something, he accepted the same, but he was disagreeing with the same earlier. So at that point of time, I learned a lot that sometimes to put up your point, you have to be persuasive, but you should not antagonize the judge. So you have to be persuasive, but in limits. So what I am trying to submit is, when you are master of your facts, you are fair, you are persuasive, you can get the orders. And what I want further to submit is that a lawyer is, this is a general saying, you know, that if your brief is good, the lawyer can get the orders. Well, I disagree with that. Lawyer has to use his creativity and try and envisage the questions. As Sishodia sir said, you have to be prepared for each and every question which the court might put to you. So don't go with a predetermined set of facts in your mind. You have to envisage certain questions which the court might put to you. So your arguments should be crisp, specific, short, no repetitions, and don't bore a judge. In a hearing case, say you start hearing in a hearing, you start with the facts, then you give the what are your grounds, and then the law and the precedents, you know, but then you should not be repetitive. Don't bore a judge. Don't argue beyond your pleadings. That is another point. Your pleadings are there. Don't go beyond that, because that will give you an added advantage to your opposite. Then, of course, don't be personal. Don't cite overruled judgments. Be very careful. Never cite an overruled judgment. That does not add to your image, because your image is everything. You know, sometimes the reputation travels faster. If your image is that you are fair to the court, you are citing the right judgments, sometimes you get an order, even if your case is not that good. So because the judge just thinks whatever you are saying, you are true to the court, you are fair to the court. So he agrees that yes, even if you have some weak ground, then too he agrees with you, because you are fair. You are saying that this is my weak point, and this is the ground, and argue in such a manner that your weak ground also looks good. So what I'm trying to say is that a young lawyer has to be specific. Then very important aspect is that don't speak over a judge. Time factor is very important, because the courts in admission matters, sometimes some judges read the file, some judges don't read the file. Then you have to go by the nature of the person concerned. Don't argue anything bad, as stated by R.N. Mathur sir, that you have to say what the you have to argue in a manner which interests him. Don't argue in such a manner which that the judge is going to be, he doesn't like that. So in my opinion, there are many do's and don'ts, but your topic, Jay, is really great, and what I can say is that everybody has spoken so well, and I could only just repeat some things. But I thank you by my heart that you called me and to be a part of this August gathering. Thank you very much.
Thank you so much, sir, for your valuable inputs. And now we are joined by Mr. SWADEEP Singh HORA, sir. He's an advocate, managing partner, SS HORA and Associates. He did his VE from MNIT Jaipur and subsequently did his LLB from University of Rajasthan. As far as professional career is concerned, he was enrolled with the Bar Council of Rajasthan back in 1999. And shortly thereafter, he set up his firm, SS HORA and Associates in Jaipur. Has over 21 years of experience as a litigator at Honorable Rajasthan High Court with frequent appearances before Honorable Supreme Court and other high courts. As far as his area of specialization is concerned, it's criminal law with emphasis on white-collar crimes, including bank frauds, tax frauds, anti-corruption, anti-money laundering, constitutional administrative law, sports law, and does a lot of pro bono and personal interest work. And to add to that, I think I'm also a very big fan of Sir's advocacy, his presentation on the dais, and even off the dais for that matter. He's always there to help out all the younger colleagues and members of the bar. So thank you so much, sir, for taking out time. The floor is all yours. I request to unmute yourself. Over to you.
Thank you, Jay, for the very kind words you said about me. And I should congratulate you for the 100th episode in which we are all participating. And I think, Jay, it's a service that you are doing for the legal fraternity at large and at such a young age. And it is incumbent upon each one of us to give back to the system which has made us what we are today. Your topic about what not to argue is a topic about courtcraft. This is what courtcraft is, as to what is to be said, and more importantly, what is not to be said. And it comes from wisdom. It comes from your own failures before a judge when you argue and you fail to obtain an order, and it sets you thinking why and what you should have said or what you should not have said, which got you a negative result. It also comes by observing other lawyers argue. And in my view, one should be a very keen observer of court proceedings to learn courtcraft. One has to see various judges. All judges have different mindsets. They have their own peculiarities. One has to understand the judges, and one has to see how lawyers make submission and understand what gets them in order and what does not get them in order. Like Sudhir ji said, he saw a tax lawyer argue and saw what could have got him a judgment in favor and what could not have got a judgment in favor. So it's all about courtcraft. And then again, it's not about a case. It's not about what you should say in a case or what should you not say in a case. It's about it's all about a lawyer. It's about courtcraft. So what you should not say is what makes you a lawyer who can obtain orders or convince the court. First, the obviously, never misstate facts, never cite overruled judgments. So these are two things one should absolutely steer clear of. As again, Sudhir ji said, it's all about credibility of a lawyer. So also Mr. Bhandari has said about this. So never try to mislead a judge. That's point number one. Second, I would say never argue in a condescending manner before a judge. Never argue in a manner as if you know more than the judge knows the law. We should always remember that it is our duty to assist the court. A judge, you have maybe 5 to 10 briefs a day. A judge has over 100 briefs to go through in a single day. His level of preparation is not expected to match your level of preparation. You have to be much more prepared than the judge. It's our duty to assist the judge to reach a right conclusion. So one should not argue. And sometimes I see lawyers saying, oh, the judge doesn't understand much about the subject. The only requirement of a judge is to be a reasonable man, and it is entirely our responsibility to assist him to reach the conclusion that we want he should reach. Obviously, we get paid for every brief and not the judge. The entire responsibility, therefore, lies on the lawyer and not on the judge. You have to explain to him about your facts, about the legal position applicable, and see that he reaches a conclusion that you want him to reach. I would also agree that while making submissions, it's our duty to maintain grace. It's our duty to be humble. Never be arrogant while making submissions in the court. It does not do you any good and doesn't take your case any further. Never make personal comments on lawyer opposite you, even if it be on a point of law. Even if it's not on a point of fact, never make an impression that your knowledge of law is more than your opponent's knowledge of law. I have seen when somebody has argued or overstated his position on law or has a mocking attitude towards the counsel on the other side, he has more often than not lost the sympathy of the bench. So therefore, one should always be courteous and humble to lawyer on the other side. As Mr. Shishodia said, quoting Mr. Mrudal, never crack a joke on the judge. You may make in suitable circumstances certain light-hearted comments. You can keep the atmosphere light, but never crack a joke or participate in a joke unless it is coming from the bench. Again, don't be repetitive in your submissions. When you make submissions, it is better to be brief, to be concise. Please understand that our role here is not to bore the judge, but to keep him engaged. A repetitive submission or unnecessary going into needless facts would bore him out. That is something which should be really avoided as I see it. Again, on the same line, do not multiply judgments on the point where law is otherwise well settled. A single judgment might do what to support you on the point that you want to make. A judgment which is later in point of time, but which takes note of various previous conflicting views or developments, that single judgment may again be cited to take you to bring your case home. On facts, don't go into unnecessary facts. The material facts which you think are necessary for you to put your case through, it is better to concentrate on that. As Sudhir ji said, there is a star argument in every case. There might be weak arguments in your case, there might be weak positions in your case, and there might be star arguments. Never argue from a point of weakness. Don't take a weak point up front. Take your star point up front. And as I think Manoj ji said, there are points, there are times when you feel that there is an obvious deficiency in your case. It's not a bad idea. It's not a bad idea to concede it, give an explanation, and move on to other points. So therefore, you have to see it's almost like in a legal battle when you are in a court, what is your strong point? What is the point you think the judge is more likely to agree upon? Then again, when you are thinking that this is your star point, as PALLAV ji said, don't think that that is the point on which judge should necessarily agree with you. You have multiple arguments in your quiver. You take one, judge is agreeing to it, and I think then you should stop if judge is agreeing with you on that point on an admission day, even if it's not a final arguing day, and you should get your order and come out with it. But if judge is not agreeing on your star point, come to another point. Show him another perspective on your case. Tell him, sir, this is another way of looking into matter, and let us see if judge agrees on it. And sometimes it happens that what you think is your star point, a judge might not really agree with it. But on a point which you think you would have, while preparing your case, thought it's not a very strong point, and judge would really buy that point out. As I said, it's all about courtcraft. Each judge has his own way of running a court. No judge is good or bad in that sense. It's our duty as counsels to make him understand and come to our point of view. So there are certain judges who would be offended if you pursue a line incessantly. You should know then where to stop. There are certain judges who are open on a point till the very last, and you can really persuade them by insisting upon a point. It all depends on judge to judge and your sense of the situation. There are no hard and fast rules to it. So there are judges who may be inclined to follow an order given by a coordinate bench. They may say, yes, we would agree, and we will pass a similar order. There are judges who will say, I would like to be satisfied myself. And at that point, a lawyer should not take things in a way as if the things are to be taken personally. You should be flexible. You should go with the flow. You should go with the judge, because ultimately it's the judge who gives you the order. And therefore, once, there is the old saying, a good lawyer is one who knows the judge, and he's better than a lawyer who knows the law. And by knowing the judge, I mean, you should know with the way a judge would think about a matter, the way a judge would like to approach a matter, because our role is to assist him to reach the right conclusion. So these are the basic things which I think one should do, one should or not do. And one should be really flexible in his approach, not as all my learned senior colleagues have said, never take things personally, because you have a point to make. The entire system, why we have lawyers and not parties arguing before judges, is that there has to be a buffer between the passions of a client and the logic and cool sense of reasoning which a lawyer has to place before a judge. So I think on those broad contours, Jay, I would say one should decide on what to be pressed and what not to be pressed, and what to be argued and what not to be argued. And I thank you again very much for having me here in this very august company.
Thank you so much, sir. There has to be one of the longest sessions ever recorded on the virtual amicus, and definitely the finest ones. Only when all the senior members and senior lawyers deem it appropriate, we can have a Q&A session. Only if you think the time would permit. And the one more thing that I wish to clarify, at the beginning of the session, I did mention a quote that was by Mr. Akhil Sibbal, senior advocate. So just to clarify, I stand corrected there on individuality and conformity. So if the floor is ready for a Q&A session.
Yes,
Go ahead.
Yeah. Sure.
So I just have two quick questions. Number one, as far as usage of legal maxims is concerned in the submissions that we make, do you think that really helps, sir? Because the experiences that I've had personally, every time I use them, they did not go well, go down well with the bench. So it's open to anybody who wishes to answer.
Yeah, Jay, would you like me to answer to that?
Of course.
We are being recorded, so got to with a kind of it's like got to be careful on that. Legal maxims, I remember over the years gradually it has gone down. There was a time when I started off, not only legal maxims, we used to refer to English case laws. Okay. And now the thing is, I think I see in the Supreme Court, it helps you tremendously. It is very much in use. I've seen Bombay High Court, I've seen Bangalore, but I see attempts in Jodhpur, but I'm not seeing at Jaipur at all. Jaipur, you are talking about legal maxims. Jaipur gradually, I think again it is picking up. There was a time that even referring to case laws also was becoming kind of extinct. You are not required to pick up books, and cases were being decided on factual aspects, which I think is not really right. That is not for the development. So I would say, but then we should not stop at that. We should continue with legal maxims. We should continue with all the possible case laws, because otherwise our growth as a lawyer would stop. You are not only in Rajasthan High Court. The moment you step out, Jay, Supreme Court, your legal maxims would be welcomed and they'll get you the desired relief. I think legal maxim that really sets up your case, and you don't have to say much. You just have to, your facts, a legal maxim, and maybe a case law. That should be the end of it.
I agree with Sudhir Bhaiya. That in Jodhpur also, if you use a legal maxim and explain, the judge also feels that you are well versed with the matter, you have understood the matter, and so you are able to explain the matter in a proper manner. So I suppose you should use it, and as Sudhir Bhaiya said, I think it has to be welcomed, and it is being welcomed at Jodhpur. I've just seen in Jodhpur that it is being welcomed.
I have a different perspective on that. I would say a legal maxim would surely show your legal grounding, your good legal grounding in law. And a legal maxim, in a matter to be argued and to give an additional point to the judge is always very welcome. But I think the judges, one should be extremely simple and clear in the submissions made to the court. My view is that your submissions should be so uncomplicated that even if a student of, say, class 5 or class 7 is here, he should get point which you, it should be very, very, and according to me, drafting styles, very verbose, longish sentences, or very complicated use of words, it should be kept extremely simple so that it is easily understandable to one and all. That's my take on it.
Can I add something? Jay, I fully agree with my friends, good friends, that legal maxims should be advanced. The legal maxim is the very soul of the law. Why I say so? Reason being, when you are arguing in the higher superior courts, in the High Court or the Supreme Court, whether it is a Mumbai High Court or whether it is Jodhpur or Jaipur or respective of the places, the law of precedence, the law would be developed, and a good law will be developed when a judgment is based on legal maxim. If a judgment is in facts and circumstances of the case, then it is not a law of precedence. Therefore, in my opinion, the case law should be on the basis of the law maxims. And if your legal maxims are decided, only then we will justify a judgment based, and it will become a law of precedence. Therefore, I agree with my friends. Try to be simple, but do not forget about the law. Ultimately, when you are arguing in the superior courts, it is the law which is being laid down, and that is to be followed by the trial courts, lower courts. Therefore, law maxims have their own relevance, and they should never be forgotten.
Very well, sir. Thank you so much. So, and lastly, the kind of approach that a lawyer needs to adopt, because some have a storytelling approach, some narrate the entire incident factually and then subsequently come on the legal aspect, or being assertive, or should we be aggressive? Now, does it depend on case-to-case basis, or does it depend on bench? The approach that a counsel needs to adopt on the dais.
Jay, will you permit me to speak first?
Sir, please go ahead.
One thing I believe, don't distinguish between the bench and the bar. Both have greater responsibilities. No one has the smaller responsibility. As I said, it is ultimately you are trustee of the profession. When the law is developed, it is not developed for a particular case. It is developed for the entire society. Therefore, don't distinguish between the bar and the bench. Both have equal responsibility. Don't look towards your opponent. Don't look towards the bench. Look towards the law. And the moment you look towards the law, only then you will reach to a right conclusion. I can get relief from a particular place. I cannot get a relief from another particular court. Please forget about this. To become great lawyer, see, successful lawyers are many. Number of persons earned money in this profession or that profession. We may get success in a particular case. Eventually, I firmly believe, no, we are trusting. And therefore, keep eloquence, be straight, speak truth, and have courage to speak truth. Your responsibility is not in any way manner, lower responsibility. Don't underestimate the capacity and role of a lawyer. He has equal responsibility. Yes, of course, you have to be courteous towards everyone. Everyone includes your assisting counsels. Everyone includes your opponent counsel. Everyone includes the bench. Therefore, please look toward the law only. And then, only then you will become a... Thank you.
Jay, slide I would like to add. Yes, we are there?
Yes.
Yes, sir. Please go ahead.
Yes, Jay. Just adding on, let's say, there are two things. One, being a successful lawyer, the other, being an eminent lawyer. We should try and be an eminent lawyer. And I think then things would fall in place. And what I would say, whenever we are making our submissions in writing, we always, I think we are using the word humbly, okay? And which I would say in the court when we are making a submission, this is what I learned from, I've very closely worked with Mr. F.S. Nariman. I've closed even Mr. K.K. Venugopal. And there's one thing which I learned from him was that whenever we are making a submission in the court, we should be making in a humble manner, but never say that it is my humble submission. That is one thing which I said. And anyway, that is something which he elaborated later on. That never say it's a humbly request, humbly submitted. He says write it, but never use it in that way. So whatever we are giving to the courts, you asking about factually, how exactly, I think give the facts in brief, crisp, and ultimately, as we are saying, what in the best possible manner from the court, making an impression on the court and getting the relief for your client. I think that's our duty, that's our responsibility.
Jay, in addition to what Sri R.N. Mathur Sahib said, as well as Sri Sudhir Gupta ji, being a successful lawyer and an eminent lawyer, I think Sudhir ji rightly invest that it's always an eminent lawyer, because you have to be very humble, polite in your submissions. But so as the facts and law are concerned, unless you are thoroughly prepared, you'll not be able to persuade the honorable court or the honorable judge, as the case may be, to make out a submission in a more perspective and corrective manner. So one has to be very polite, submissive, but you have to be assertive so far as making submissions on facts as well as law. That's all. Thank you.
I would also second what Virendra ji has said, Jay. So it's all about being persuasive rather than being aggressive. The approach is to choose between being aggressive and being persuasive. Ultimately, it's for the judge to decide. If you think you have amply made your point clear to the judge and he has understood the point, then I think we should leave it at that, rather than hammering it in, knowing that he has understood but he's not agreeing. I think then it's better to move on a different point.
Yeah, if I could be excused, if you permit me, I think,
Absolutely, sir. Please.
Okay, thank you. No. I'm just like, I have something personal to attend to. If you permit me, and if
Definitely, sir. Please.
If I could take the leave of all, and I'm extremely, extremely thankful. Pallav, RN, SWADEEP, MANOJ, Virendra, and Jay, of course, you, and RAJDEEPAK. Okay,
Very
thank you so much. Thank you.
Yeah.
Bye.
So nice to you.
I think the time has come to wrap this up, because this has already exceeded an hour and a half. And anything that anybody wishes to say before we wrap this up? Probably a minute or two, and then we'll wrap this up. Very well. Thank you so much to everyone. It's not easy to get hold of some of the busiest names from the legal fraternity on a weekend, because that's the only time they all get for their respective families. The key takeaways: it's a profession of persuasion. One has to be humble towards the bench and be well prepared on both facts and law. Approaches differ, but the profession remains the same for everybody, because it's a evolving field. And once again, thank you so much, everyone. It's the longest session on the virtual amicus. Indeed, very special because it's the 100th episode, but it's the panelists that have made it even more special. Our email is mentioned on the channel. In case of any queries, feel free to write to us. We will obviously not be in a position to forward the same to our speakers because they charge per appearance, and some even do that for every wave that they take. But I'm sure this is pro bono work, so I will not receive a bill at the end of the session. And it's goodbye for now. Thank you all. Thank you.
Thank you. Thank you, Jay. Thanks a lot.
Thank you, Jay.
Thank you.
Good day.
So nice.
Have a good day.
Thank you.